Okay, let's see. I think we have both the attorneys present. So if we go on the record here in Moriarty versus Moriarty, case number 2319411. If I could have counsel put your appearances on, please.
Good afternoon, Your Honor. Jennifer Duspencoy on behalf of Barbara Moriarty, who's present with me in my office.
David Grunst on behalf of the defendant, who is incapacitated, and Mary Moriarty, the guardian, is here as well.
Okay, thank you. This is set for a status conference today. I think the last time we talked was back in March. So Ms. Dukes-McCoy, on behalf of plaintiff, can you kind of tell me where things are at right now?
Well, from our perspective, Judge, the parties have exchanged a lot of information. We seem to have disagreements on what is separate property and what is marital property. And I think that those are things that the court is going to have to decide for us. We went to mediation previously as part of the guardianship and conservatorship case, and we made some agreements. But I think that in this case, we're going to end up needing to have a trial on this matter. So it's purely assets and liabilities.
Okay, Mr. Grunts?
Well, we've slowly worked our way through a number of the documents. Some of them we can read, some of them we can't, that we're having a hard time doing. I just received back stuff from the guardian and got some questions from her that I need to get answered by Ms. Moriarty, get some different documents. I still think this can be worked out. We need to have a meaningful settlement conference sometime down the road. I don't know if, based upon the documents that I have, if I need anything more, but well, like I said, we're slowly working through those. And there are a lot of documents that we have to go through. So I would ask the court to at least set this for mediation down the road. Maybe we can, between that and a settlement conference, we can come up with some sort of settlement.
All right. How about this? What if Ms. Dukes-McCoy, I mean, I understand what you're saying, and if we do need to get a hearing, I'd rather have that, get that scheduled and then have the parties work on any kind of settlement negotiations or mediation in the interim. So how much time do you think we would need if we do have to have some kind of evidentiary hearing to address those issues?
I believe it could be resolved in a day, Judge.
Okay. Mr.
I'm thinking more like 2.
2, okay. All right, so what if I set this for a 2-day evidentiary hearing? We set it like 90 to 120 days out. And that'll give the parties time to prepare as well as time to engage in further ADR. If they want to do that. Ms. Dukes-McCoy, what do you think of that time frame?
I think that's appropriate, Judge. Just, I guess, understanding that, defendant needs to be prepared to go to trial too. So if they want some more time, I think that allows that time as well. And then we've got something on the horizon. So I think that's fine, Your Honor.
Mr. Grunst, is that time frame going to work for you, do you think?
I would like more like an October date. That would be fine.
Okay, Ms. Dukes-McCoy?
That seems a little far out to me. I don't know what the court schedule looks like for, availability for a 2-day trial. I mean, it might be October anyway. I would prefer a little bit sooner, but I guess I don't necessarily have an objection to October.
Yeah, I mean, that's, we're at June now, hard to believe, I guess. So that really does put us in that 90 to 120 day time frame that I kind of mentioned. So I think that's reasonable. And then the court will set this for a status conference prior to that trial date, probably about 30 days prior to that. And that way, before everybody commits to being ready for 2 full days of proofs, we can check in and see if that's really going to be necessary, whether some of the issues are resolved or narrowed. And then that'll also give us a chance to address you know, things like trial briefs and so forth, if it looks like we are gonna have some type of hearing. So I'm gonna get it on the calendar for a 2-day evidentiary hearing. At about 120 days, the court will set it for a status conference 30 days prior to that. And then we'll go from there. Ms. Stutzman-Coy, anything else that I can address for your side?
Not today, Your Honor. Thank you.
Mr. Grunz?
No, Your Honor, I'm fine. Thank you.
Okay, thank you. All parties are free to disconnect on this file.
Thank you.
Thank you, Your Honor.
Mr. Wims, what case are you appearing on?
Your Honor, it's on the Wolf versus Calcasa County case.
Okay, great, thank you.
And good afternoon, everyone.
Good afternoon. Then I've got somebody connected on the phone here. The last 4 digits are 1584. Can you unmute and tell me who you are, please? Right. Mystery individual. I'm going to put them back into the waiting room because I don't know who that is.
Says Chris.
Sorry, go ahead.
No.
Okay. All right, let's go on the record. This is Wolf versus Calcasa County Road Commission, case number 1913121. If I could have both counsel put your appearances on, please.
Robert Wims appearing for the Wolves by Zoom. Thank you for that courtesy.
Andrew Speaker appearing for the Road Commission by Zoom. Thank you, Your Honor.
Okay, so this got docketed today. I'm obviously not in Calcasa County, so I haven't had a chance to look at the file to see where things are at. I believe that this was a hearing that we set as a control date. Mr. Wims, can you kind of tell me where things are at from your side?
Sure, Your Honor. We're probably at the 95th percentile of done. Andrew can back me up on this. What happened was we did all this stuff. We got all the signatures we needed. We got it surveyed, the easement. They actually had to jigger that a little. It was done wrong the first time. We got it done the second time. And then the county asked that instead of an easement, we do a dedication. We didn't have a problem with that, but we just got the paperwork the other day. We sent it to our clients. I've spoken to them today. They don't have it yet. They actually went to the mailbox today, but the bottom line is they expect to get it any day. They'll sign it. They'll return it to us. We'll get it to Andrew. And Andrew, let me ask you this. Does this need to go in front of the commission one last time or are we good?
It does. Once we get the final signed version, we'll get it in front of them. And then as soon as they have their next meeting, we'll get it in front of them for the final approval. So
Your Honor, we're almost to the finish line, what it comes down to.
Okay, all right, sounds good. I will just set this as another control date, 90 days out. If for some reason we don't have it handled by then, that at least gives us time to check in. Obviously, if it's taken care of and the court signs the final documents, we'll take that hearing down. But thanks to you both for continuing to work towards finalizing the resolution. Mr. Wims, anything else I can address for your side today?
Other than Lord willing, I hope we're done long before 90 days. Granted, there's not much to do. Thanks. We are your oldest case, aren't we, at 19? I mean, can't we be the winner?
It's got to be out there, right? You guys are definitely in the running.
It's not quite the honor we would think, but it's an honor of some sort.
right.
Well, thank you all.
Okay,
Y'all take care.
Thank you. You guys are free to disconnect.
Cool. Bye
Thank
now.
you.
Okay, next hearing is set for 2 o'clock. For a break until that time. Okay, looks like we have everybody connected, on the Lester versus Lester matter, so. We'll go on the record and Lester versus Lester, this is case number 2319497. And if I could just have both counsel put your appearances on, please.
Travis Grote on behalf of the plaintiff, James Lester.
Mark Dundon on behalf of defendant Cindy Lester.
Okay, I have here in the file a proposed consent judgment of divorce. Mr. Grote, were you ready to proceed and take proofs from your client today?
I am, Your Honor. Mr. Lester, you appear to be muted. If you can unmute yourself, that would be helpful. There we go.
Okay. All right, and Mr. Dundon, from your side, are you guys ready to proceed as well?
Yes, Your Honor.
Okay, so Mr. Lester and Miss Lester, if you could both raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Thank you. You can lower your hand. And Mr. Grote, please feel free to proceed with proofs as your client.
Thank you. Mr. Lester, please state your full name for the record.
James Blond Lester.
Before you filed your complaint for divorce, were you a continuous resident of Otsego County for at least 10 days?
Yes.
And also, had you been a continuous resident of the state of Michigan for at least 180 days at that time?
Yes.
Were you married to your wife on April 13th, 1993 by a person authorized to perform marriages in the state of Michigan?
Yes.
And sir, what was your wife's name at the time of the marriage?
Cindy Jean Pawson.
Is it your understanding that your wife wishes to have her maiden name restored to her?
Yes.
To the best of your knowledge, is your wife currently pregnant?
No.
And you and your wife do not have any minor children at this time, is that correct?
No.
Sir, you alleged in your complaint for divorce that there had been a breakdown of the marriage relationship to the extent that the objects of matrimony had been destroyed and there was no reasonable likelihood that your marriage could be preserved. Was that true at the time that you filed your complaint for divorce?
Yes.
Does that remain true today?
Yes.
Is there any possibility of reconciliation with your spouse?
No.
And you and your spouse have entered into a proposed consent judgment of divorce that Judge Mertz has in front of him. Is that correct?
Yes.
You understand the terms of that document?
Yes.
Are you satisfied with those terms?
Yes.
Through discussions with me, you understand that as to spousal support, neither of you can come back before the court and ask for spousal support in the future if the judge grants the judgment as it's presently worded.
Yes.
Okay. And you understand and agree with that, is that correct?
Yes.
Do you believe that it's a fair and equitable division of the marital estate?
Yes.
And are you asking the court to grant your request for a divorce today based on those terms?
Yes.
I have no further questions, Your Honor.
Thank you. Mr. Dundon, did you have any questions for Mr. Lester?
No, I don't. Thank you, Your Honor.
And did you want to take any proofs from your client?
Just very briefly, Your Honor, please. Thanks. Okay, please state your name for the record.
Cindy Jean Lester.
And you also read and agreed to the judgment of divorce, correct?
Yes.
And you find it to be fair and equitable?
Yes.
And you are currently not pregnant, correct?
I am not.
Okay, and you also understand you're waiving spousal support in perpetuity, correct?
Correct.
Thank you. No further questions, Your Honor.
Mr. Grote, did you have any questions of Ms. Lester?
I do not.
All right. Court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court has reviewed the proposed judgment, finds that it's generally equitable and contains all the provisions required by statute. The court will grant the divorce, and I've signed that judgment. Mr. Grote, anything else that we need to address for the record from your side today?
No, Your Honor. Thank you very much.
Mr. Dundon?
No, thank you, Your Honor.
Okay, thank you. That concludes this hearing. All parties on this case are free to disconnect at this time.
Thank you.
Thank you.
All right, we have somebody joining on the phone with the last four digits, 1584. Can you tell me your name, please?
Penny Patrick.
Penny Patrick. Okay. I also show that you're connected by Zoom as well. Did you
My
prefer-
computer has not allowed me to audio on the last couple of things I've done.
Okay, got it. Okay. All right. I have your hearing set at 2:30, so I'm just going to put you back on hold until that time, okay?
Certainly. May I ask a question?
Sure.
I had requested the name change if you grant this today.
Okay.
Is there, I asked this morning, is there something that I needed to fill out?
Let me take a look here one second. There will be, yes. But I'd rather address that at the time of your hearing at 2:30, okay?
All right. Yes, sir.
Okay.
Thank you.
Thank you. Okay, are you Mr. and Mrs., is it Nagi?
Yes,
Okay, great. Am I pronouncing your name correctly?
that's correct.
Okay, so we'll go on the record now in Nagi versus Nagi, case number 2419637. The record should reflect both parties are present today by Zoom video. I have this set as a final hearing to finalize the divorce in this case. Is that how you both wanted to proceed today?
Yes,
Yes.
Okay, great, thank you. I'm gonna have both of you raise your right hands. I need to put you both under oath. And then I'm gonna ask a series of questions to each of you. These questions are the questions I'm required to ask to establish the grounds for divorce under Michigan law. Do you both solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
yes,
Yes.
Thank you. You can lower your hands. Mr. Nagy, most of the questions will be for you since you are the filing party here. You filed for divorce in this case, is that correct?
that's correct.
At the time that you filed, had you been a resident of the state of Michigan for at least 180 days?
Yes,
Had you been a resident of Otsego County for at least 10 days?
yes,
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
yes,
Does that remain true today?
yes,
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
no,
Under the proposed judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
yes,
Okay, and the proposed judgment of divorce indicates that there aren't any assets or debts that need to be divided up and that the two of you are going to keep whatever personal property you have in your own possession. Is that correct?
that's correct.
And that you don't own any real estate or real property together.
Correct.
Okay, thank you. Ms. Nagy,
Yes.
have you heard all the questions that I asked Mr. Nagy?
Yeah,
Did you hear all of his answers?
I did.
Do you have any reason to believe that any of the answers that he gave were untrue?
No,
Okay, do you have a question? I see you're talking about something there.
I thought the house was in my mom's name and we're deeded to it. We're on the deed for it, so I don't know how that works. We're both living here still currently.
Okay, both of your names are on the deed to the house?
Yes.
Okay, so are you going to leave that way, or do you guys have some agreement about what you're gonna do with that?
We have an agreement on what we're gonna do with it.
Okay, and what is that agreement?
The agreement was during the file of divorce that she would sign off on the house. And it would just be solely on my name.
Okay, is there any debt associated with the house, a mortgage or anything like that?
Yes, there's still a balance.
So Mr. Nagy, you're gonna assume all the debt, and then Miss Nagy's gonna sign a quitclaim deed to you?
That is correct.
Miss Nagy, is that correct?
Yes, that is correct.
Okay, that's something that would need to be in this judgment, so I'm gonna write that in, and once I write it in, I'll read it back to you to make sure that it's what, that it accurately reflects what your agreement is. Can you give me the address of that property?
480 Metelsky Road, Michigan.
Miss Nagy, is your name on that mortgage as well?
It's on the quitclaim deed, yeah.
No, but the mortgage, the debt that's associated with the house, is your name on that loan?
No, it was just in my mom's name and she's since passed last year.
Okay, but, so there's two different things. There's the deed to the property, and then there's the mortgage or the loan. And
Yeah.
I just need to, whose name is on the loan?
I'm not on it, no.
Neither one of us are on the loan.
Okay. And you said your mom passed, Miss Nagy?
Yes, last year.
All right, so who's gonna pay up? I'm a little confused because typically, you know, if there's a debt in a person's name after they pass, then that's taken care of through the estate, and all those debts have to be settled, so. I don't know how a loan can still be out there for somebody who's no longer living.
Well, the credit union, we signed the quitclaim deed, so they have the house, we're making payments on the house.
So did you guys take over the loan then?
As far as we know, we just did it through the quitclaim deed and they never advised the paperwork that needed to be done after the death. They're fully aware of her passing of last year. And we just go in there and make the payments every month.
So did you have to sign some documents where you guys assumed that debt with the credit union?
Yeah.
Yes. That was 2 years ago, I believe, or 3.
Okay, so both of your names are on the loan then too?
Well, as far as just on the quitclaim deed and then part of the loan for maintaining the property.
Okay. So the issue that I'm seeing is, number one, that loan's gotta be in one or both of your names, and that the loan is different than the deed. So the deed is what gives you ownership of the property. The loan is what, you know, gives you the legal obligation to continue paying for the property. And so, you know, the problem is, and it's fine, we can go forward today, but Miss Nagy, you need to understand that if you're on that loan, if Mr. Nagy defaults on it or something going forward, that it could affect your credit and everything, as long as you understand that, you know, part of this isn't you. Okay, you understand that then?
Yes, I do.
Okay, all right. Okay, so I'm gonna read this back to you, and I want to make sure that this is accurately reflects your agreement. So the property at 480 Metelsky Road, Gaylord, Michigan, is awarded to the plaintiff. Mr. Nagy will assume any debt on the property, and defendant, Ms. Nagy, will quitclaim her interest to the plaintiff, Mr. Nagy. Does that sound right?
Yes.
Yes.
Okay, all right, thank you. Okay, so a few more questions for you then, Ms. Nagy, now that we've got that taken care of. Let's see, Ms. Nagy, you also will not be receiving any alimony or spousal support. You understand that you also would be waiving that forever and would not be able to come back later and ask the court for that?
Yes.
Okay, and do you agree, besides this issue involving that property, that you both have divided up any assets or debts, and that you're going to keep whatever personal property you currently have?
Yes.
Are you asking to have your last name changed?
Yeah, I mean, if you put it in there, do I have to do it within a certain time frame or?
Yeah, if I put it in this judgment, then after today, your name will legally be changed. So if you're not sure, then you should probably hold off on that.
Okay.
Okay, are you currently pregnant?
No.
Okay. The court finds that the statutory grounds for divorce have been met by the testimony of the parties. The court will sign the judgment of divorce, so your divorce is final as of today. If either of you would like copies of this judgment for your records, you can get that here at the clerk's office downtown Gaylord. Do either of you have any questions at all?
No, sir.
No.
Okay, thank you. That's all for today, and you're both free to disconnect at this time.
Thank you.
Okay, Mr. McNally, are you calling in on the Charlevoix County matter?
I am, Your Honor. That's the APJ Properties Birchwood construction matter.
Okay. And do you have, is there opposing counsel in this case?
Yeah, Jack Deegan from Pluckett-Cooney is representing defendant.
Okay. Have you spoken with him recently? I don't see him signing in, and it's unusual for him not to be.
Yeah, I can. So the case, we resolved the case the day prior to our scheduled mediation, and the insurance adjusters were finalizing a release, which I asked him about last Friday, and they were working and getting that to me. I can try him on his mobile phone quickly if you'd like me to see if he can join.
No, if you've got the case resolved, so it's just a matter of just getting closing documents to the court.
We're just closing the documents, and it would be great from my standpoint if we just set a control date or something to just make sure we get this closed out.
Yep, I think that makes a lot of sense as well. So let's, I'll set this as a control date. How much time do you think you'll need to get things wrapped up?
Well, I think the draft is done. I mean, I'm hoping it's this week. I mean, Jack assured me over the weekend that he was going to try to get the draft to me as soon as possible.
Okay, so I'll just set the control date 60 days out. I know that's a ways, but that way that gives us plenty of time for any hiccups in between without you guys having to appear for another hearing. If or when the court receives the closing documents, then I'll just take that control date down. Anything else that I can address for you here today?
Nothing. Thank you very much, Your Honor.
Okay, thank you. You're free to disconnect at this time.
Thank you very much.
Okay, Miss Patrick, are you still there?
Yes, sir.
Okay, Mr. Patrick's signing in, so just give me 1 second here.
Unmute. There we go. Think I got it.
All right, Mr. Patrick, are you able to hear me okay?
Yes, it is, sir.
Okay, thank you. We're on the record now in Patrick versus Patrick, case number 2319520. We have Miss Patrick present by phone. Mr. Patrick is present by video. This is set as a status conference in this case. The last time we met was back in April, and the parties were going to participate in mediation. It looks like you did do that, and it looks like you were able to reach an agreement. Mr. Patrick, is that correct from your standpoint?
We were able to reach an agreement, Your Honor, but I don't believe that the terms were met. And I, as much as I want this divorce over with today, Your Honor, I have a few questions.
Okay, what are your questions?
For one, she emptied my buildings and took everything out of 2 different buildings that she wasn't supposed to take everything out of. She shut me down business-wise. She took a sleep number bed that said it wasn't supposed to be taken, which she says is in the building somewhere. She just went about this very, very unprofessionally and poorly and left me in bad standing with the house that she's supposed to give to me. She didn't give me the vehicle titles within 10 days like she was supposed to. Is there any repercussions for any of those actions? And if they're not, then I just would like to be divorced.
Okay. Well, to answer your question, I can't really give you legal advice as to, how to proceed if she hasn't complied or followed through with the settlement agreement. That's something that you would need to consult a lawyer about if you wanted to.
I have the order to show cause, Your Honor. I have that here, and pictures and damage, and I'm going to turn it in. But if there's no benefit to it, Your Honor, it would be best to just end the marriage.
Well, again, I can't really tell you what to do. That would be the job of a lawyer. And if I give you advice, then I have to give Miss Patrick advice too, and that's not the role of the court. My one question, Your Honor, is will I be able to do it after today? If we do get divorced, will I still be able to do the order of show cause? That depends on a few different things. I mean, well, first of all, we can't go through with the judgment of divorce today. I can't finalize it because that's a document that you would have to submit to the court, and that hasn't happened yet. That's a form. It's called the judgment of divorce. It's the final document that the court signs to finalize things. And so that would need to be submitted. So we can't finalize the divorce today anyway. And again, in terms of whether or not, you have legal recourse, I wouldn't be able to give her that kind of advice. So I can't give you that kind of advice either. So what I can do is, I can set this for another status conference. If you want to pursue whatever you want to pursue, you'll need to do that in the interim, okay?
Okay.
Ms. Patrick, I know do you have any questions about going forward? What's your position?
No, Your Honor. I understand that Mr. Patrick feels that I had removed things that I were not supposed to remove, but under the business of Escape the Cabin and through the receipts of the years I've been in business, I had removed my business. This has caught him off guard as he thought a building would include a business.
A joint owned business.
I'm sorry.
A joint owned business.
I'm sorry. I have evidence otherwise, but that is neither here nor there. The misunderstanding of a sleep number bed is not been taken. I saw a white pump in a box that I thought was part of it. I had indicated to his representative that came with us, my daughter and son-in-law, to remove my stuff and my business stuff. I did not take anything that I was not, and I left many things that were.
Oh, there's
And
lots of garbage left.
I would be more than happy to put effort into cleaning, but I did not wish to stay longer than I needed to.
You are not allowed in the building if I can say anything after what you've done to me.
All right, you know.
I do.
I don't want to get into I don't want to get into a debate about what has or hasn't happened yet.
Correct.
Because it's really not the point of this hearing today.
May I?
Go ahead.
I have completed all of the paperwork. I have the titles and the keys. I have them here. I have done this before with Mr. Patrick in February to find him failing at transferring it out of my name, driving with my plates and insurance. I had only asked that we waited till the last minute. He has, at my last contact at the Register of Deeds office, he has not completed the paperwork that he agreed. I have filled it all out for him. I have set up the insurance to be transferred and contacted with him. I have done what I can do. I did not ask for this divorce, but I would like to move forward in it.
All right, well, again, I'll set this for a status conference in 30 days. I would encourage the two of you to try and work out whatever these issues are between now and then. If you're able to do that, then we can finalize the divorce. If you're not, then the only other way that the court's going to have to move forward is to, set this for a hearing. And just looking through the settlement agreement, it looks like there's a lot of assets. This is the kind of case it's complicated enough that the two of you really ought to have some legal counsel helping you with this, so that, number one, you're able to present your cases effectively before the court, so that I can make a good decision. And number two, to advise you of your rights and what your recourse are, because I think the two of you have a lot of questions and issues about that part of it.
Your Honor, are we only not getting a divorce because he failed to file for the judgment paper?
No, it sounds like you guys don't have an agreement. It sounds like there's a lot of issues still out there. So
Complete agreement that has been performed right up until these last few days.
well,
And I
Mr.
believe
Patrick saying
strictly
that.
verbiage.
So here's the problem. He's saying there's things you were supposed to do that you haven't done, and you're saying there's things that he's supposed to do that he hasn't done.
I'd like to say something, Your Honor, if I could.
Everything is
If I could just say something, Your Honor, the paperwork that she's talked about has been completed. Everything has been completed. The Sheboygan paperwork cannot be delivered to Sheboygan for title work. She will have to do that herself, just like I will have to do to the Ironwood. The only thing that has not truly been completed is I just found a power bill for one of the addresses that I have to get up to date. But short of that, the stuff that she's talking about, I have completed. She just doesn't know because I just did it.
Yeah,
Thank you, Your Honor.
I understand that's what you're saying.
I did it. I have it.
I don't know who has actually done what at this point. You're both telling me that you've done everything you're each supposed to do, and the other one's saying that you haven't. So
well,
I can show you it. I have it. I can show you it, Your Honor. It's right here.
Well, the whole point, again, if you're not able to reach an agreement and hammer all of these things out between the two of you, I have to have a hearing where you come into court, you present evidence. I have to make determinations about what that evidence means. You can't just hold stuff up in front of a camera, and I can't just go on everybody's word. So that just opens up a whole different process that we have to follow. I can't just make informal decisions based on what you guys are telling me here.
Okay, Your Honor. I can tell you, Penny, I did do this work, and I would follow through with the judgment if at all possible. How it is written, how it stands on this very day, I believe that we are 99.9% okay, Your Honor. Do I feel that there might have been a slight, to me? Sure. but I am willing to concede at this time. You tell me which paperwork to sign, Your Honor, and I believe that she would feel the same way, and we can just be done with this. At this point, with no changes to nothing, no how, nowhere, I'm okay with.
Okay, so, Mr. Patrick, you're the plaintiff, and it's usually the plaintiff that submits the final document. That document is called a judgment of divorce. You
Okay.
can find that, it's a form that you can find where you got the same forms to file for divorce.
Okay.
And that judgment needs to be filled out, and it also needs to have attached to it the settlement agreement that you both reached through mediation.
Okay.
And then I'll set this for another hearing, and that needs to be submitted to the court before the next hearing. I will send you both a notice of the date and time of that final hearing. So you'll know about that ahead of time.
Very well. The sooner the better. Thank you, Your Honor.
All right, Ms. Patrick, do you have any other questions?
No, Your Honor. I will leave these items, keys and stuff at the location if
All right,
that is
that's something that you and him need to work out. I'm not going to get involved in that. That's not part of my role.
I have no questions other than I'm waiting.
Okay, Mr. Patrick, you also need to send a copy of that judgment to Ms. Patrick as well.
She has it from mediation. Oh, the judgment of divorce. Yes. Yes, Your Honor. And
Yeah.
can I just mail that, or does it have to be served?
It has to be served, and that way we'll all be looking at the same thing at that next hearing, so we can go
Okay.
through it.
Okay.
All right, thank you. That's all for today, and you're both free to disconnect at this time.
Thank you.
Thank you.
All right, looks like we have all parties present, so we're on the record now in Glazier versus Glazier. This is case number 2319311. Mr. Blumberg, do you have your client there with you?
Yes, I do.
All right, thank you. And Mr. Glazier is present today by Zoom video as well. Let's see, last time we met was back in April. At that point, the court set today's as a status conference, and Mr. Glazier was to have that time to retain a new attorney if that's what he wanted to do. On behalf of plaintiff, Mr. Blumberg, can you tell me where things are at today?
Yes, Judge, regrettably, we're kind of at a standstill. Before Mr. Garfield withdrew in this case, we had sent him some document requests regarding Mr. Glazier's business so that we could have the business valued. We've retained the services of a company to do that, but we've never received any of those documents. I don't know whether Mr. Glazier has his file now or whether Mr. Garfield retained the file, but we're right where we were back in April.
Okay, Mr. Glazier, I don't see an attorney that's made an appearance on your behalf. Are you going to be representing yourself going forward?
Yes, Your Honor.
Okay. Well, and did you get your documents and everything back from Mr. Garfield?
So Mr. Garfield sent me it's not, it's like a JPEG type thing, some kind of a, and I don't know, I don't have them at the moment, Your Honor. I apologize. I don't know how to retrieve them off from the electronic way that he sent them. I'm gonna have to try to get some help with that, I guess.
All right. So Mr. Blumberg, I guess where we're at, it sounds like Mr. Glazier is going to be representing himself. I think all I can really do today is set some dates going forward, some discovery periods. Sounds like there's some discovery that you're going to want to engage in. And has there been mediation? I'm assuming there has not been mediation yet.
No, we have not.
Okay. So
may I ask a question?
Yeah, 1 second, Mr. Glazier.
Okay.
Mr. Blumberg, what kind of time frame would you be looking for discovery and mediation in this case?
I would hope we could get it done within 60 days. I mean, what I'll do is, if it's okay, I'll send the document request directly to Mr. Glazier. And I know he has a CPA that does some of his work. And maybe I can send it to the CPA, but yeah, I think 60 days hopefully will be enough to get everything done.
Okay, Mr. Glazier, what was your question?
That was pretty much my question. I did submit to Mr. Garfield the last 3 years taxes, and I don't know if he submitted that to Mr. Blumberg or not, but I did submit those to him. The best way that, I mean, as long as it's okay with Mr. Blumberg, I will okay it with my CPA, Hanley. It was Hanley and Miller. It's just Hanley CPA now, because I'm not gonna try to present myself as an accountant or anything with the electronic. I don't have any clue how to do any of that stuff, unfortunately.
Okay, so Mr. Blumberg, if we say 60 days for discovery, 90 days for mediation, and then set a status conference at 90 days, do you have any objection to that?
No objection, Judge.
Mr. Glazier, do you have any objection to that?
No, Your Honor.
Okay. Okay, so the court will send out the notice of that next hearing about 90 days out. The court will refer this to the community mediation for that process. Mr. Blumberg, anything else that I can address for your side today?
Judge, we would, Mr. Glazier has vacated the marital home. He's residing elsewhere. His stuff has been placed neatly in a garage. We would hope that he would come and pick it up. It would just make things a lot easier. I don't know if you need to get involved. Hopefully you don't, but if Mr. Glazier could make arrangements to pick up his belongings, we would be, it would help move things along.
Mr. Glazier, is that something you can take care of?
Yeah, I'm a little confused on how to take care of that, because I was being pestered by the plaintiff so much that I had to get a personal protection order. My phone was being called and about 100 to 200 times a day. Now, since she has called me and I didn't report it, we've had a quick conversation. I would hope that we could speak. The relationship is done. I would hope that we could just resolve this, and I feel like we probably can, but I don't want to get myself in trouble by violating a protection order, and I'm not trying to get her in trouble either. I want to be left alone. I don't want to be pestered all day, every day while I'm working. I don't want to be called while I'm at home. Just come see me and stuff like that. So I don't know exactly how we should take care of it. I would be very, I would be willing to just go and get my stuff with my crew, but I just don't, I don't know how to go about that, I guess.
Well, Judge, maybe Mr. Glazier and I can work out an arrangement to take care of that.
Okay, yeah, it sounds like there's no objection to it in principle, so I'll leave that to the parties to arrange for that. Otherwise, we'll be back in 90 days. If things are resolved, we can also use that date to finalize and take proofs. So that's all I have for today. All parties are free to disconnect on this file. Thank you.
Thank you.
Okay, looks like we have council connected. All right, we'll go on the record now. This is Michigan Schools and Government Credit Union versus Trevor Pickelman. Case number 2319476. Council, if I can have you put your appearance on the record, please.
Yes, good afternoon, Your Honor. Michael T. Mamet, P81102 on behalf of plaintiff.
All right, and Mr. Pinkelman is present by Zoom as well.
Yes, sir.
This is set today for hearing. Mr. Mamet, you filed a motion for summary disposition. I did have a chance to review that. So was there anything that you wanted to present by way of oral argument today?
Well, Your Honor, I would like to let the court know that no response was filed. The matters deeming our admissions admitted was filed, and under the court rules, under the bench book, those are now judicial admissions and beyond contestation at this point. There's no genuine issue of material fact. The defendant, although I don't believe he's disputed anything, he just needs time to pay it. There has been no proffered defense meeting the court rules either. At this point, I believe motion or the summary disposition would be more than appropriate, if not required by the court rules.
All right, thank you. Mr. Pickelman, anything that you wanted to say in this matter?
No, sir.
Okay. I did have a chance to review the file overall. Again, I did have a chance to read the motion and brief that was filed in support of the motion for summary disposition. I do note, as indicated by Mr. Mamet, that there was no response filed. So under the court rules, the court finds that summary disposition is appropriate, and the court will grant the motion for the reasons stated in it. And so, Mr. Mamet, if you would file an order under the 7-day rule reflecting that the court is granting the motion. Anything further, Mr. Mamet, that I can address for your side today?
Not concerning the motion, Your Honor. However, because my defendant is here, would we be able to get a breakout room for a moment?
Sure, Mr. Pickelman, are you willing to talk to Mr. Mamet here privately in a breakout room?
Sure.
Okay. All right. Other than that, Mr. Pickelman, did you have any questions at all?
No, sir.
Okay. That concludes this hearing, but I will put the two of you into a breakout room. Just give me 1 second. All right, and the court's next hearing is set for 3:15, so the court will be in recess until that time. Okay, looks like we have everybody connected, so we'll go on the record in Patricia Johnson versus Trillium Companies, case number 2419593. If I could just have counsel put your appearances on, starting with plaintiff.
Good afternoon, Your Honor. Mark Connolly on behalf of the plaintiff, Ms. Johnson.
Good afternoon, Judge. Mark Mueller appearing on behalf of defendant Trillium and Aspen Village.
All right, thank you. We're on the record here today for purposes of pretrial scheduling in this case. And so I just wanted to get some input from both of you in terms of how we want to go forward. Mr. Connolly, have you and Mr. Mueller talked at all about dates, or do you have any particular timeframes that you want to request for the scheduling order?
Your Honor, Mr. Mueller and I have had an initial conversation about this case, nothing specifically tied to dates. I would propose a standard 6 months, I think, for discovery. I think that would be plenty of time. And Mr. Mueller and I have had a number of cases before, and we work well together, so we shouldn't have many issues with that.
I agree, Your Honor, and I think 6 months is satisfactory.
Okay, so we'll set 6 months for discovery. Any objection to having mediation within that period of time?
No, Your Honor.
None.
Okay, and I'm assuming based on your statements that you guys would be able to agree on a mediator. Do you think that'll be an issue?
No, Mark, if you want to throw some names out right now, we can probably pin it down. I've steered away from Barney. He's getting kind of pricey.
Yeah.
Don't tell him I said that.
Well, you're usually the next guy on the list, Mark.
I'll be happy to mediate it. Yeah, we can talk about it. I don't want to take up the court's time.
Yep, for sure.
Right.
Judge, if you want to just give us 2 weeks to let you know, that should be plenty.
Okay, perfect. Are there any parties that aren't in that are we going to need to amend pleadings or add parties or anything like that?
No, Your Honor.
Yeah, very unlikely.
Okay. Any objection to having a dispositive motion cut off 30 days following the close of discovery?
No, Your Honor.
Sounds fair to me.
Okay. And then what I'll do is just set this for a status conference at the close of discovery. If the case didn't resolve through mediation or otherwise, then we can see where things are at and talk about, further ADR if the parties want to do that, or just kind of get things on a trial track. Mr. Connolly, any other dates that I can address for your side here today?
None, Your Honor. I think that covered everything.
Mr. Mueller?
No, Your Honor. I can't recall. Do you have a standard, like a witness list filing deadline in your orders?
No, I haven't done that. Since the discovery rules kind of changed, I found that most parties are submitting that stuff on their own now, so I haven't been putting that in the orders, but I'd be happy to address it for you guys if you want to.
I'm fine with leaving it open.
Yeah, that's fine.
Okay. All right, sounds good. Well, I'll put these dates into an order. I'll get that out to both of you, and we'll go from there. Thank you. You're both free to disconnect this time.
Thanks, Judge. Thanks, Mark.
Thank you, Judge. Thanks, Mark.
All right, looks like we have all council connected, so we'll go on the record in Payton Jones versus Mson, Otsego. Case number 2319251. And if I could have council put your appearances on, starting with plaintiff, please.
Good afternoon, Your Honor. Jenny Sikorsky on behalf of the plaintiff.
Rebecca Walsh, also here on behalf of the plaintiff. I expect to stay muted throughout.
May it please the court, Ralph Valatutti appearing on behalf of defendants June Murphy, David Miner, Jessica Kiley, and Ronald Jonette.
And good afternoon, Your Honor. Gretchen Olson appearing on behalf of the Otsego Mson defendants.
Okay, thank you. We're on the record here today. There's been a number of motions noticed up for hearing. And I guess my first question to plaintiff's counsel, there were 3 motions filed by the defendants, and I believe all filed by Mr. Valatutti, or attorneys on his behalf, but I did not get any responses from plaintiffs on those. So Ms. Sikorsky, I mean, are those at issue, or what's your plan for proceeding on those today?
They are at issue, Your Honor, and I apologize because our responses should have been sent to the court, and I believe delivered. I think they were sent out overnight delivery on Wednesday. So I apologize if the court has not received those responses.
Yeah, I actually checked with the clerk's office at lunchtime today, and at least as of that point, they hadn't come in yet. So I haven't had a chance to review what your response is. I guess what I'd like to do is just proceed with oral argument on that. I'll hear from defense counsel and see what their position is in terms of the court having an opportunity to review your response. But are you prepared to go forward with an oral argument today?
I can, Your Honor, with oral argument, yes.
Okay. All right. So with that matter kind of being addressed, I guess the first thing I want to start with is the one that I do have briefs from both sides on and haven't had a chance to review, and that's plaintiff's motion. And I guess, Ms. Sikorsky, I mean, basically what you're arguing in that motion is that the PLC was added on by mistake, and you want to be able to correct the caption to reflect the correct party, which is Dr. Murphy in her capacity as a doctor, not her corporation. Is that correct?
Correct. So what happened, Your Honor, is June Murphy individually has always been a defendant. She was a defendant at the outset of the litigation. We filed a motion to amend the complaint to add her PLC. And when that amended complaint was filed, a clerical error was made. So the PLC was added to June Murphy's name twice. So now the PLC is reflected twice in the caption, and Dr. Murphy herself individually is not. So it's just to amend the caption to reflect it back to show June Murphy as an individual defendant, and then the PLC also as a defendant.
Okay. Mr. Valatutti, what's your position on that?
So, Your Honor, the defendant, Dr. Murphy, in first responsive pleading, we filed a partial notice of non-involvement of Dr. Murphy individually, indicating in pertinent part that at all times relevant to the plaintiff's complaint, she did provide professional services through her PC or PLC. And then the plaintiffs filed their first amended complaint and left out Dr. Murphy as an individual. Now the plaintiffs want to rename Dr. Murphy as an individual. Under the rules, with regard to affidavits of non-involvement, the defendant can move for partial summary judgment based upon the affidavits where there is no genuine issue of material fact. During the between the original filing of the partial non-involvement of Dr. Murphy individually, the plaintiffs have taken her deposition, and they found in her deposition that her professional services at all times relevant to the treatment and care of this young mother, Cheyenne Jones, were services provided through her PLC. There's no contradictory evidence. Additionally, the statute with regard to medical malpractice defendants makes the PLC and the individual one and the same. Therefore, under the rule, the test regarding futility, the second part applies specifically to this. That is to say, it merely restates an allegation already made against the PLC and is surplus. We believe that the individual defendant should not be named. There is no basis set forth in the complaint for piercing the corporate veil and bringing an action against the individual. The PLC is already in the case, and the PLC has been, and the plaintiffs have had the opportunity to take Dr. Murphy's deposition and offer not one shred of evidence that suggests that she, that her PLC does not stand as a corporate veil under which all of her medical malpractice liability in this particular case is well contained. Excuse me, Your Honor, if I may. Janice, can you close my door, please? Okay, sorry for that. There's a little bit of distraction going on here. That's our position on that, Your Honor.
All right, thank you. Ms. Olson, does Mson take any position on this motion?
We do not, Your Honor. I mean, I support the argument that Mr. Valatutti has made. But beyond that, nothing additional.
All right, thank you. Ms. Sikorsky, anything in response?
Yes, Your Honor. I just want to make sure that it's clear that June Murphy is already an individual defendant. There are already individual allegations against June Murphy as the individual defendant. So we're not seeking to add her or amend the complaint in any way. It's seeking to just amend the caption to reflect the correct defendants that already exist in this case.
I disagree, Your Honor. There's no evidence in this case that she provided any service outside of her PLC. Yes, her PLC is pled against for with regard to actions of medical malpractice, but there's no allegation of fraud or that she allegation that would support a claim that the plaintiffs are entitled to pursue her individually. There's no such allegation in the complaint. Only allegations of professional malpractice that are covered under both the statute, the contract, and the testimony of record in this case.
Okay. All right. I did have a chance to review again the motion as well as the response, taking that into account along with what the attorneys have argued here today on the record, which is consistent with what was argued in the briefs. The court finds that the amendment should be allowed. This frequently happens when one party wants to amend their complaint and the other party cites the futility portion of the court rule in an argument against it. And what ends up happening is what is kind of happening here, which is it really turns into a motion for summary disposition or partial summary disposition. And it's my view, and after reading many cases interpreting the court rule governing amendments of pleadings, that language regarding futility isn't meant to turn a hearing on a motion to amend a caption, as we have in this case, into what is essentially a full-blown hearing on a motion for summary disposition, where the court has to make determinations about questions of fact, questions of law regarding, as Mr. Valatutti brought up, piercing the corporate veil and so forth. I don't think that's really the standard that the court should apply in a motion to amend. And I certainly think those may be valid arguments, and certainly the court would have to take each one of those up in due course, potentially on a motion for summary disposition. But again, I don't think that's the standard that the court's looking at when it's merely trying to determine whether or not to allow an amendment. I think the futility language is meant to apply to situations that are so clearly, a claim is so clearly not going to be enforceable even with an amendment that it's futile on its face. And if the court has to, research questions of law, make rulings about whether or not summary disposition would be appropriate in order to determine this, then I think we've gone beyond what I think is again just a basic decision about should this claim have the opportunity to go forward so that arguments can be made. And so at this point, I think we're not at a point where the claim is so futile on its face and so unenforceable that the court should not allow the amendment. So for those reasons, the court will grant the motion. And so Ms. Sikorsky, if you can file, and again, I tend to agree, I think this is more of a kind of a scrivener's error, I guess, for lack of a better term, than it is an actual change in the claims. So Ms. Sikorsky, if you can submit an order under the 7-day rule reflecting the rule of the court, as well as an amended caption on the complaint.
Will do.
Okay, and so then moving on to defendant's motions, I'm just going to go in order that I read through them. Mr. Valatutti, your motion regarding plaintiff's expert, my understanding is essentially, it looks to me like you're just looking for some type of agreement by the plaintiff saying, look, okay, we aren't going to call these people. And so therefore you don't have to worry about deposing them. You're not going to list your witnesses, your experts, and plaintiff hasn't been willing to do that. So you either want him to say, look, we're not going to call these people, so you don't have to worry about deposing them, or you want to be able to engage in discovery. Is that a fair synopsis of that motion?
I think you've got it. I think you've got it reduced to its simplest terms. All that I would add is that we have discovery deadlines. Why, if it becomes the position of the plaintiff that they are going to use the expert, and we're a week away from the discovery deadlines. Well, the discovery deadlines are effectively vitiated. So that's what I was trying to prevent. As we were getting close to these discovery deadlines, narrowing the issues and narrowing the number of experts that we would have to depose was our goal in offering that we would not be utilizing X number of experts if you do not utilize experts on the same subject matters. I thought it was plain and simple and straightforward. But the plaintiffs objected to that, so that we went ahead with this motion. Was filed, by the way, May the 9th of this year, almost a month ago. We've had discussions with plaintiff suggesting that an order can be entered sometime in July. I guess it's the plaintiff's fear that one of my other experts will go into an area that would otherwise be covered by the plaintiff's 3, or one of the plaintiff's 3. And of course, that they're entitled to have their fears, but the problem is discovery is limited in time.
Ms. Sikorsky?
Yes, Your Honor. So we, myself and Rebecca Walsh from my office met with Mr. Valatutti via Zoom on May 22nd, I believe it was, in an attempt to see if we could come to an agreement with the motions. And I thought we had an agreement as to this particular motion. We had discussed our fear being that should one of his experts testify or say, for example, that there was an issue with the placenta that was causative of the plaintiff's injuries, then we obviously want to be able to call our placental pathology expert to rebut that argument. At the end of that Zoom call, or while discussing that motion, it was at least my belief that we had come to an agreement that we would enter the order after standard of care and causation experts had been deposed, to make sure that we didn't foreclose ourselves of potentially needing to call a rebuttal witness should such testimony be given.
I think the point we couldn't agree on was a date, because the date is contingent upon the closing of discovery. And that's related to another motion. In April, we asked plaintiffs to give us dates so that our expert could examine Payton. And all those dates have gone by. And we haven't had an opportunity to have Payton examined by our experts, so that deposition is going to be delayed pending decision by the court on that second motion. So we're in agreement, but exactly when this order would be entered and under what circumstances is not specifically I can't get specific agreement to it. I don't believe.
Oh, I thought we had specific agreement that we would file it after July 17th, which I think was the date for the OBGYN expert, or July 18th. So that was my understanding at the time that we had discussed it. But that's our position, Your Honor, and our issue with entering an order at this point. We feel that it's premature and want to be able to leave that door open to call rebuttal expert if necessary, if there's testimony given by defense experts as to those specific issues.
Mr. Valatutti, I mean, if the court were to allow under that circumstance the extension of discovery after that July date, I mean, would that solve the problem from your standpoint of having that July date be the time that parties would either agree or not agree on striking those witnesses?
Well, it should be, but at this point, it being the third day of June, Dr. Kolebson will not be able to do his exam between now and July 17th. I want to be upfront about that. And we've lost quite a bit of time with regard to his doing his examination, and he is a causation witness. He is a neuropsychiatrist, so his deposition will not be done, assuming the court allows for us to have an independent medical exam. His deposition won't be done by July 17th.
Okay, let's move into that issue then. And again, I did review the parties, at least your motion, Mr. Valatutti. So, and the supporting documents. So I understand the basis for you wanting to have Payton examined by that particular doctor. So, Ms. Sikorsky, maybe you can tell me what your position is and what objection plaintiff has to that.
Sure, Your Honor. So we don't feel that any good cause exists as is necessary pursuant to MCR 2.311. Payton is nonverbal. This doctor is a psychiatrist, so it's not like he would be able to ask her any questions which she would be able to answer. Based on defendant's motion, it appears that he is going to be giving an opinion as to the cause of her issues and the causal connection of her issues related to her labor and delivery, all of which can be gleaned from the medical records, all of which defense counsel has, her therapy records, her evaluation records. If there's any reason that he would need to see Payton, there was a video observation that was done of her at defendant's request before we took the deposition of mom, Cheyenne Jones. So that video also exists. I didn't see any good cause that defendant set forth in their motion that would require Payton to be subjected to any kind of physical or mental exam when all of that information is available to the doctor in other forms.
Okay, thank you. Ms. Olson, I know I didn't ask you about the expert issue. I apologize for that. If there's anything you wanted to add to that. But in particular, this motion regarding the IME, does Mson take any position on that?
Your Honor, we simply support Mr. Valetuti's argument as well. I mean, I think there clearly is good cause to have an IME of this witness, and I think that it's set forth in Mr. Valetuti's argument in his motion, and certainly orally he'll convey that good cause as well. I mean, to suggest that medical records are going to convey a picture to a neuropsychologist as opposed to visually seeing and communicating with the young child is entirely different. And I think the video itself is very short, maybe a 4 or 5 minute clip. So I do believe that there is good cause for it, but I'll let Mr. Valetuti speak more on that issue.
Okay, thank you, Mr. Valetuti. It's your motion. Any response to Ms. Sikorsky?
I have seen their written reply. It was the first time I noticed that they were raising these kinds of objections, because it was kind of a situation where we asked them if they could give us dates, and then they told us, well, we don't think he's qualified. He's the leading expert in the world on autism spectrum disorder, by the way. And then I saw in their papers that there's no good cause. I received last week their report of an examination that has been conducted by their expert, Roger Huckfeld, 1 year ago, a report prepared 1 year ago, where he personally attended his independent medical exam of the plaintiff. Later this week, I'll be taking the deposition of their pediatric neurologist, Stephen Glass, and I'll bet that he has conducted an independent medical exam of the plaintiff himself. So the plaintiffs want to have independent medical exams supporting their expert witnesses' testimony, but at the same time, they suggest that good cause does not exist for the defendant to have such an equal opportunity to have Payton examined by Dr. Kolevson. The leading case on this point is Burris versus KAM Transport Incorporated, a case in which the lower court decision not to allow a defendant to have additional, not an original, additional independent medical exams was reversed and remanded for further proceedings. In the context of the court rule, good cause simply means satisfactory, sound, or valid reason. Now, this is a case, mind you, in which the cause of the plaintiff's developmental delay is disputed. We say it's autism, and this expert is the leading expert on autism in the world. And we do not want him to be impeachable for the reason that he had not conducted an examination of sufficient quality, quantity, or duration of the plaintiff to hold an opinion in that regard. I believe it would be reversible error to deny the defendant an independent medical exam in the case. But more than that, the fact that the plaintiff wants to have independent medical exams of their own, but to deprive, excuse me, the plaintiff wants to have independent medical exams of their own, but deprive the defendant of independent medical exams is outside of the spirit and the context of the rules on the physical examination of persons. And in their papers, they added that if the court allows the independent medical exam, they want to have an attorney present or to have a video of it. And again, the case is the Burris case, wherein the court, let me make sure about that, because this was something they raised by papers that just came to us last week. There is a Michigan Supreme Court case on this very issue that suggests that there is no right, independent, absolute right for an attorney to be present or for that examination to be videotaped. The court may order that, but it is nowhere found within the precedent that has interpreted that rule that anyone has to be there. And it was noted in the Supreme Court case that the language concerning videotape or presence of an attorney has been opposed by members of the medical profession who believe that such obstacles interfere with their independent ability to evaluate. And so not only do I believe that it would be reversible error to deprive the defendant of equal opportunity for a physical and mental examination in this case, but we would oppose the presence of an attorney or a video. And let me say something further about the video. There was a case in, I believe, New Jersey where attorneys videotaped an examination done by Richard Katz. And then they showed the video to their experts who were not videoed during their independent medical exam. And their experts brought into the case another issue saying, well, Dr. Katz didn't perform a full, complete, and thorough examination, though the defense had no opportunity to compare and contrast the physical mental examination conducted by the plaintiff's experts, because obviously they did it in private on their own time. And in this case, at least with regard to one doctor, 1 year ago, which raises another issue, which we will bring up with the court later concerning timely supplementation of expert reports. But two things. Number one, I believe we're entitled to an independent medical exam. We're going to need now expansion of the time within which to do it. And we object to them videotaping that exam or having attorneys present. We welcome the presence of the parents to be at Payton's side, but not an attorney and not a video.
All right, thank you. Ms. Sikorsky, I didn't have a chance to review your written submissions. Is there anything else that you wanted to say on that topic in light of what Mr. Valentucci raised?
Just, Your Honor, so I heard Ms. Olson mention when she was talking, referring to this as a neuropsychologist. My understanding is that this is a psychiatrist, and neuropsychologists may perform neuropsychological testing. Psychiatrists don't. So the question becomes, what exactly is this person going to examine? If he's not doing any testing, Payton can't answer any questions. And I just heard Mr. Valentucci talk about a physical exam. I don't think a psychiatrist would be doing a physical exam. Then what is it that is necessitating an in-person IME with this psych expert who's a psychiatry expert?
Well, they'll have the opportunity to obtain an education regarding He's a neurologist and psychiatrist. He's board certified. All psychiatrists are also certified in neurology. They'll have an opportunity to examine Dr. Kolevson and determine whether or not he's qualified to do this exam, and just exactly what the nature, breadth, and extent of his exam consisted of. And they'll be able to find out all of the things that they apparently don't know and would otherwise sequester to the knowledge of a neuropsychologist. A neuropsychiatrist is not a doctor of medicine and is not a person otherwise allowed to diagnose or treat under the Michigan Medical Practice Act. A neuropsychologist is allowed to perform neuropsychological testing. Dr. Kolevson is a psychiatrist who's devoted most of his life to the study of children with autism. He's devoted most of his life to understanding the causes and also those things that do not cause autism. He's devoted his life to the types of treatment and care that can have beneficial effect and those types of treatment and care that have no beneficial effect. And he's also able to testify quite extensively regarding the problem of autism in this country and our inability to, as a scientific, the inability of medical science as a scientific body to fully understand why so many children are developing this problem. He'll also be able to testify as to the genetic aspects that are extant in this case, and that are extant in a significant, statistically significant number of cases of autism. If they have problems with regard to qualifications, the methodology of his examination, his ability to back up his opinions with literature, then they can bring a Daubert motion. It should not be a motion to block his exam.
Okay, thank you. Mr. Sikorsky, one last question for you. Mr. Valatutti indicated that the plaintiffs have had experts evaluate and examine Payton in this case. Is that the case? And if so, then why should the defendants not have the same opportunity and the same access that the plaintiffs' experts have?
Well, we had our life care planner go out in order to do his life care plan that he has to do. He has to observe what the child's abilities are. So in terms of that, I wouldn't call that an exam because he's not he's observing the child so he can put together the care needs that the child's going to need. In this case, as I said before, Your Honor, even everything that Mr. Valatutti just told me in the court that this doctor is going to testify to is fine if that's what he's going to testify to. I just don't see any reason that necessitates him having to see Payton in order to be able to do that. And I would point out, Your Honor, understanding that you didn't get a copy of our response, is that if the court is so inclined to order it, that the order also does state that somebody from plaintiff's counsel's office be present for this exam, and or that it also be videotaped.
With regard to that, their life care planner is an MD, and he called his evaluation performed on July the 26th of 2023. His evaluation to evaluate her physical, psychological, sociological, vocational, educational, and recreational needs. So he's going to testify to more than just that of a life care planner. He's going to be testifying as an MD.
Well, he'll be testifying. He'll be testifying to her life care planning needs and to her life expectancy. I don't know that matters whether he's an MD or not, but that's what his testimony will be.
Well, he said more than that. He said he's going to evaluate her physical, psychological. He's going to evaluate her psychological, sociological.
Well, I need to cut you guys off because we still have one more motion to talk about, and I've got a hearing that was supposed to start at 4 o'clock with different parties that motion for summary disposition. So I've got to get this moving along here, and I think we're just now arguing semantics. Looking at the standard, which both parties have accurately stated here in the court rule, the court finds that there is adequate cause to order an IME in this case. I think defendants should have reasonable access to have their expert conduct an examination of Payton. You know, I think there are all kinds of reasons why that would be useful and should be allowed for the defendants. You know, even if Payton is not verbal, that in and of itself means something. And I think the examination should be allowed in this case. I am going to, and I think we got some time for the parties to do some negotiating on how that's going to take place. I think it's reasonable to put some safeguards in place so that Payton isn't unduly subjected to, you know, not that this would happen, but I think, you know, I think it's reasonable for plaintiffs to want to have some safeguards in place given the age and the disabilities involved here. So I'm going to grant the defendant's motion to conduct an IME by their named expert. I'm going to give the parties 30 days to negotiate over how that is going to be conducted in terms of who's present and the length of the examination and all of those things. If the parties aren't able to reach an agreement to that, Mr. Valatutti, I'm just going to ask that you file a motion. I think we're going to have time to get that heard and taken care of based on your statements here today. But I want the parties to see if they can come up with a way to have this conducted, because I really think, at least based on the information I have now, I don't know that it's necessary for a lawyer to be present. I don't know that it's necessary for it to be videotaped. And that's why I want the parties to take a crack at the parameters of the exam first, because you're all in a much better position to know what's appropriate for Payton. And to the extent that you're not able to come to an agreement, then I would expect that motion, that the parties would give the court some very specific information about Payton and why they think what the other side wants isn't appropriate, not called for. So I know that's a lot that I just said, but in essence, the court's granting a motion to compel the IME. The court's going to give the parties 30 days to negotiate over how that will take place. To the extent that the parties aren't able to reach an agreement because the defendants are the one requesting IME, then Mr. Valatutti, the court would ask that he file a motion and the court will rule on how it will take place.
Thank you.
And then the last motion, Mr. Valatutti, is your motion to compel the deposition of some individuals who are non-parties but who have been involved in the care of Payton.
That's correct, Your Honor. There are two types of individuals involved, if I may just shorten this. Certain of the individuals are affiliated with community mental health and have been providing services to Payton there in Gaylord. And then there are the group of individuals that are were providing Payton with free appropriate public education in the Mount Morenci area until Payton stopped. Actually, I can't even say Payton stopped. I don't know what happened, because it appears as though she was scheduled to begin free public appropriate education at Pied Piper School in the geographical area that is appropriate to her, and she didn't start it, and she was asked to her parents were asked a number of times to come in, and there appears to be a controversy between the father and the grandmother as to why Payton was not continued in independent, free, public, appropriate education. So we want to take the depositions of those individuals. We notified the school district and the Department of Community Mental Health, and we received responses from their lawyers saying, well, you need an authorization from the parents or one of them. And we provided those authorizations, and the plaintiffs don't want to sign the authorizations. That's basically the reason for us filing this motion. We believe we're entitled to take the depositions of these people. I think that the plaintiffs are objecting to my ex parte conversation. I don't want to waive my right to ex parte conversation to find out which of the individuals I do need to take the dep of and which I don't. But beyond that, I believe we're entitled to take these depositions because they have put not only the mental, physical health of Payton into perspective, but there's a number of other issues that arise as a consequence of Payton missing approximately 2 years of public education and speech therapy. And there are issues regarding the community mental health providers who have been requesting, and asking for speech therapy that has not been provided. We want to find out what that is. There are a number of issues that this is relevant to. And we want to fully and completely investigate those. So we filed our motion to either obtain an order from the court that we be allowed to take the depositions of all the individuals we've named in the motion, or a smaller list based upon our ex parte conversation with those individuals who have responsibility for not the execution, but for providing free and appropriate public education to Payton, as to who and what who are the people in those organizations who are responsible for seeing to it that she is provided with independent evaluations from the intermediate school district, and what was done between mom and dad to see that Payton got speech therapy as ordered by her physicians more than 2 years ago.
Thank you, Ms. Sikorsky.
Yes, Your Honor. So I just want the court to know that we have no objection to Mr. Valatutti taking depositions of the non-parties that he requests to take. However, MCR 2.305 is clear as to the correct process as to how we'll go about taking depositions of non-parties, and that is to send a subpoena, which hasn't been done to my knowledge. I haven't seen any subpoenas, and had they been sent, we should have received a copy of those. And then at that time, if the non-parties themselves have any issue as to the subpoena, they can then come to the court and ask for certain conditions, whether it be a release or that they don't want to give testimony or whatever relief that they may want to request from the court. So that is our issue, is them just not going through the proper channels and subpoenaing the witnesses, and instead asking us for a release, which brings up my concern when Mr. Valatutti is now talking about ex parte communications as well, in terms of getting us to sign a release that then could be construed as permitting ex parte communications, which then gives the look that may have been authorized and agreed to or even requested by Payton's parents. So that, this is a motion that I'm not sure why it was even filed against us, but that is our position as it relates to this motion, Your Honor.
Well, Your Honor, we went through a process of contacting the individuals, not the individuals, but the organizations, and the organizations through their lawyers were negotiating with us a means of agreeing to our taking of those depositions, so long as we received authorizations. So the plaintiffs never responded to us when we asked for authorizations that you just go ahead and subpoena them and you can take their deps. That's not what the way they responded to us. They responded to us by silence. And so we've sent them these authorizations, and I think as time goes on, they come up with more reasons not to sign them. I think that they're obstructing our ability to do that. And I would ask the court for a simple order allowing us to take these depositions. The rule that Ms. Sikorsky is citing is correct by subpoena or court order. At this point, I'm asking for a court order.
All right, thank you, Ms. Olson. Any argument that you wanted to weigh in on here at all?
I don't think so, Your Honor. I mean, you know, Ms. Sikorsky's argument will get us right back to the end result, but it'll be that much more delayed. So I think it's about time for a court order, frankly.
All right, Ms. Sikorsky, anything further that you wanted to address on this?
Only the fact.
Go ahead, Jen.
Only the fact that when we had also discussed this motion with Mr. Valatutti when we talked on May 22nd and had discussed the court rule and that the step should have been to subpoena these witnesses. So
we started this process of asking for authorizations back in April. I don't understand their opposition, to tell you the truth. The Supreme Court in Holman versus Rassick indicated that the defendants are entitled to ex parte conversations. I want to take their deps, but I want to find out which of them have the knowledge that is necessary. I don't want to waste time taking the depths of people that don't have knowledge concerning the case.
So, Your Honor, so here is the thing, and Mr. Valatutti just said it, that the motion itself is clear on its face, that it's a motion to compel the depositions, and now we're talking about ex parte communication. So this is the issue, or the problem I have, is that instead of just following the court rules, which is very clear, to subpoena the non-parties, you're asking us to sign a release or an authorization, which now apparently is to be intended for ex parte communication, which is being done differently than seeking an order or a separate motion for ex parte communications with the treaters, Your Honor.
Your Honor, these authorizations weren't printed by me. They were provided to me by the attorneys representing the community mental health and the intermediate school district. So we'll go ahead with the depositions. I would just like an order. They will respond to an order and they'll allow the depositions to go ahead. We'll take depositions of all of them. I modify our request.
All right, well, I'm seeing this kind of as a cart before the horse thing. And, you know, I get not wasting time on pro forma, you know, issues of strictly following court rules when it's going to get us to the same place eventually. But I also think, you know, that Mr. Sikorsky's got a point here. They're being asked to sign these releases without knowing exactly how these things are going to be used going forward. And I think if we follow this procedure step by step, then it puts the plaintiffs on notice that, okay, these people have been subpoenaed for depositions. We're going to be signing releases so that those depositions can take place. That's one thing. Just, you know, ahead of time, executing authorizations or releases to allow defense counsel to speak with these individuals about anything. You know, I think that's a little bit broad, and I think asking for an order from the court at this point is not warranted under the court rule. So at this point, the court is going to deny that motion. I think if we're at a point later on when there's defendants are coming to the court with a more specific request, or going to plaintiffs with a more specific request about when they're going to be taking these depositions, exactly who is going to be releasing information, then I think at that point, if an order may be warranted. But at this point, again, I think it's a little bit of the cart before the horse. So the court is going to deny that motion. To summarize, the court is granting plaintiff's motion to amend the caption. The court is granting the defendant's motion for an IME with parties to negotiate over how that's going to take place. The court is denying defendant's motion at this time to compel plaintiffs to provide releases or authorizations. And then with regard to the initial motion on defense experts, the court's going to hold off ruling on that at this point. I think we're going to have to extend discovery anyway, so that defense expert can conduct that IME. So the court's going to hold that ruling on that motion in advance. And Ms. Sikorsky, I'll ask that you prepare the order regarding plaintiff's motion to amend. Mr. Valatutti, I'll ask that you prepare an order reflecting the ruling on the other motions.
Thank you, Your Honor. Thank you for your patience.
Okay, thank you. And I'm sorry, I've got everybody off at this point and move on to my next case.
Your Honor, can I ask you a procedural question about the responses? Because I do have the date and time they were received at the court, and I was wondering if we should resend them.
You know what, I don't know, but I'm 20 minutes past the time. So for my last hearing, so I need to move on. That's something that we can hammer out later.
Okay, thank you, Your Honor.
Thank
All
you.
parties are disconnected this time. All right, Mr. Fico, is it Fico or Fico?
Fico, correct.
So, Mr. Fico, you're here on behalf of TBF Financial, is that correct?
That is correct.
I see Mr. Bach, or somebody signed in under Mr. Bach's name. However, I don't see any other attorneys. Oh, we've got somebody on the iPhone, but you're muted.
I apologize.
Okay, your name, please?
My name is Scott Norton. I'm attorney for the defendants TBF. I'm sorry, my defendants 45 Degree and Dean Bach.
Okay, very good. Thank you. We're on the record now in file number 2319505. This is TBF Financial versus 45 Degree Hospitality and Dean Bach. Appreciate counsel's patience. I got caught in a hearing that went about 20 minutes past the time it was supposed to go. So thank you for your patience. We're on the record here today for purposes of a hearing on plaintiff's motion for summary disposition as to defendant Bach only. I did have a chance to review the motion in brief. I had a chance, Mr. Norton, to review your response as well. Mr. Fico, is there anything that you wanted to present today in terms of oral argument?
Your Honor, I don't have anything substantive to add to my briefing. I'd like to point out that the discovery, I did receive some discovery. I don't believe that there's any showing of prejudice certainly there's plenty of time for those discovery requests to be complied with. They were initially served at the end of January. Admittedly, got out of order with out of sequence. I filed the initial disclosure very early February. So there's at least 2 cycles of 28 days there for the responses. So I don't believe there's any prejudice shown thereby. Also, there's been no showing of prejudice by the fact that the main borrower entity defendant is the subject of a receivership. Nothing to indicate how that might impinge or negate impinge on the defendant's ability to prosecute his defense or create some kind of a stay when in fact the individual defendant is not referenced at all in the receivership order. So I would ask that there is that summary disposition be granted, judgment be entered on the basis that there is no good faith dispute that Mr. Bach executed the guarantee document, that the primary borrower co-defendant is in default of that, and under the guarantee, Mr. Bach is obligated to render performance to the plaintiff.
All right, thank you, Mr. Norton.
Well, yeah, Your Honor, working with the case law cited by the plaintiff and in my responding brief, we have answered to an illegible contract, which is the underlying obligation. And my client, Mr. Bach, and TBF dispute the signatures on that document. We have answered, we have provided discovery responses, although, you know, I put in my response the out of order of the discovery, including, you know, the request for admissions. Now, the problem there is I sent a letter to opposing counsel and he acknowledged that he got it wrong. And he said he would file his initial disclosures. But so now what am I, and I requested that he properly put in order his discovery. They failed to do that. However, in connection with this upcoming motion, we responded to what was out there. I don't know if that's what initial disclosures have a purpose. It helps to focus or narrow the discovery process. And so I don't know if what they first served out of order was what they wanted answered, or when it was going to be answered, or when the time set was to be answered. We did. We answered anyways. And we denied. We denied the underlying agreement by 45 degrees. And there's a big problem there, Your Honor. They're stayed on this action. Then there's and if you look at their complaint, it says, if you read the plain reading of the complaint states that Mr. Bach's guarantee is supposed to be in support of that, which he denies. He denies the signature. He denies the document. And he gives an affidavit. There's no affidavit in their motion. We gave an affidavit. Mr. Bach gave an affidavit. Mr. Bach's here, by the way. So on 3 separate bases, we challenge under Nurembacher versus Globe Furniture Rentals, which cites the Radke Everett case, the 42 Mish 368. There's plenty of questions of fact here for this thing to go to a trial. Unlike in Nurembacher, where the defendant, the non-moving party, well, maybe not the defendant, but the non-moving party failed to do anything. They just made mere allegations. We've got 3 levels. We've got an answer. We've got responses to discovery, and we have an affidavit. And So we believe that we are properly before this court to, if you want, if decides to move forward on this matter, maybe hold it without prejudice for us to get to the bottom of this transaction. But we believe that we properly put forward to this court sufficient evidence, documentary. The answers to the discovery included bank statements where we claim that we paid this debt. This debt was not a loan or a lease. We paid it up front from monies that we took from a bank. So we have defenses with documentary evidence, sworn statements, and discovery.
All right, thank you. Mr. Fico, any response?
Yes, I'd like to point out, first of all, that we did in fact file an affidavit attesting to the breach and the damages. It was filed right with our motion, is attached right to it. So I don't know how a defendant can claim an affidavit was never filed. With regard to the authenticity of the signatures, the affidavit to properly put those signatures into dispute has to be filed along with the answer or response to pleading under 2.112E. That was not done. So that signature is deemed admitted under Michigan court rules. I'd also like to point out that what was provided in discovery purports to be an invoice. However, it's for an entirely different transaction. This appears to be Huntington Bank as the lender. Although it may be the same vendor, Tioma Systems, the same equipment vendor. This is a contract that was dated July of 2018, whereas the subject agreement was dates from 2019 and involves a different piece of equipment. The documents produced in discovery appear to relate to something like a closed circuit television security monitor type system, whereas my client's contract relates to a Ruckus TLS, which I believe is a Wi-Fi or internet system. I'm not terribly technically literate, but I believe that's what it is. It's a completely separate contract, different date, March of 2019, different equipment, different original lender. So what was provided in discovery does not even relate to the contract at issue and is not responsive to our claim that monies are still owed.
What contract, Judge? I can't read the contract. I don't know. Look at, Judge, I asked you to take judicial notice to what you have in your file. Can you read the contract? Because I can't. I can't see what it says. I don't know if there's arbitration. I don't know if there's
Mr. Norton, I'll give you a chance to respond, but don't interrupt Mr. Let him finish and then I'll give you.
I apologize.
That's okay. Go ahead, Mr. Fico.
Oh, okay. Well, Your Honor, I will likewise invite you to review the documents that were submitted as exhibits to the complaint. You can very clearly make out that it says lease agreement, very clearly make out that it describes the equipment as an LTS Ruckus, very clearly see the date of March 20th, 2019 that Mr. Bach executed it, very clearly in large print, 36-month term, $400.70 lease payment. I don't see how this document, is it the greatest, sharpest? No, but it's certainly legible. It's certainly readable, and certainly as to the material terms. If there's an arbitration clause in there, it's incumbent on Mr. Norton to bring that to the attention of the court, which has not been done.
All right, thank you, Mr. Norton.
Mike, yes, well, that's fun. That's fun if I could read it. I can't read what it says. I don't know, Judge, if you can. I can't even see what the terms and conditions of the contract were. So I pled my affirmative defenses. And in the affidavit of my client, he paid this, whatever this is alleged to be, in full, not pursuant to any lease arrangement or any guarantee. So we have questions of fact, Your Honor. Let's get to the bottom of it. First of all, let's get a contract we can read. Two, let's get to whose signatures are there or are not there. Let's get to what the terms and conditions of any type of guarantee are, if there are any. My client, under C9 and C10, has done everything that is necessary to present to this court a question of fact for a trier of fact to get to the bottom of this. And we implore this court to deny this motion and let the parties proceed.
Okay. All right. I did have a chance again to review the briefs of the parties along with the attachments to those submissions. I also had a chance to review the file generally, including the initial pleadings from both sides. Mr. Fico, as the moving party, I think correctly set forth the standard that the court's to apply to motions pursuant to 2.116C9, which is that a party's failed to present a valid defense and therefore summary disposition in favor of the plaintiffs is appropriate. And C10, that there is no genuine issue of material fact such that judgment in favor of the plaintiffs should be given. And in this case, looking first at 2.116C9 and reviewing the pleadings as well as the submissions made by defendant Bach since then, the court finds that there is adequate statement of the defense, certainly not very specifically factually developed. However, I don't think, particularly in terms of the C9 standard, that there needs to be explicit statements of expressed factual support. The party just needs to set forth and put the other side on notice what the defenses are going to be. And I think that if supported by the evidence later on that some or all of the defenses submitted by the defendant Bach have arguable legal merit. So the court finds that under a C9 standard that the defendant has stated a defense that would result in a finding of no liability later on if evidentiary support is eventually provided for those defenses. So the court is going to deny the motion under C9. Pursuant to C10, and looking at the potential factual development as well as where we're at procedurally in this case, the court finds that in their response and attachments to that response that at least as of at this time, defendant Bach has demonstrated that there are some questions of fact here such that at this point, summary disposition under C10 would not be appropriate. However, the court is going to make that ruling without prejudice. In other words, I think with some more discovery and as Mr. Norton indicated, I think some more discovery and looking into documentary support for the allegations here, I think it's entirely possible that motion under C10 may be appropriate later on after further discovery. But at this point, the court finds that it isn't appropriate at this relatively early stage in the case. So the motion under C9 is denied. The motion under C10 is denied without prejudice. In other words, once we get to the close of discovery, Mr. Fico, I think the plaintiffs would be justified in bringing that motion again upon further discovery and factual development. So, Mr. Fico, if you would provide an order either with the stipulation as to form from Mr. Norton or under the 7-day rule regarding the court's ruling today.
Thank you, Your Honor.
Thank you, Your Honor. I will draw something up and submit it for approval as to form.
All right, thank you. that concludes our hearing today. All parties are free to disconnect at this time.
Thank you, Ted.
That also concludes the court's afternoon docket. The court will be in recess until 9 a.m. tomorrow.